Hello friends, Shantanjana this side. This is our new YouTube channel which is created with the prime objective of furnishing revision videos of CA intermediate subjects which primarily appear in the subsequent CA intermediate examinations. However, the overall idea is quite simple. We just furnish revision video in a crisp and well organized format at free of cost. After or at the end of the video or each session, you will be provided with a Google form which will act in front of us as a option or as a choice of making or as a suggestion you can say for making significant videos in future. However, the overall objective of this particular channel is to maintain the unity and consistency by which we all will receive our target and be succeed in our life. However, with this initiative, let's begin this new chapter of CA Intermediate with the help of the new YouTube channel, The Balance Sheet. Therefore, without wasting any further time, let's jump to our first session on this new YouTube channel. Today we are going to revise the chapter called Declaration and Payment of Dividend, which is laid on the paper 2 called Corporate and Other Law subject. So without wasting any time, let's get started. The name of the chapter will be Declaration and Payment of Dividends. For before moving ahead, I, as a instructor, want to request you to please take your pen, pencil, or paper because this is a concept-based video session where we will discussing multiple critical things which are primarily required to be written down or primarily required to scribble on your own notes. After that, the video and its ultimate meaning will be fruitful. So let's start. Before starting, the core concept of this particular chapter or the core law of this particular chapter, let us understand the meaning of dividend. First of all, just only focus on my words. Suppose Mr. X is an individual visits in a institution with rupees 1 lakh. He instructed the banker to make an fixed deposit with the amount, and the banker promised a rate of interest of 7% per annum. It means after the end of a particular year, Mr. X will able to earn rupees 1000 rupees 7,000. 1 lakh rupees will be the principal and 7% will be the rate of interest. So 7,000 will be earned by Mr. X by investing such amount to its bank. Now, what if I would say the Mr. X, the individual Mr. X, visit to a company and proposes its director to take the money from him as an investment and he will get the equity of such company. Now, if Mr. X actually invests the amount to any of the listed company, then Mr. X would have earned the same proportion or quite different proportion as per the policy of the company for its investors. Therefore, in a shorter note, it can be said that the portion or the rate the company provide to its investor is called dividend. However, dividend is meant as it is a distribution of the profits. Dividend is a distribution of profit. It means the how much profit a company earns in a particular financial year is available for distribution as dividend among its shareholders. Who is the distributor of such amount? The distributor shall be the concerned company on which we are making investment or we are invested as a shareholder. To whom the amount is distributed, the amount is distributed by such company only to its shareholders. Now, you may ask a question, in which type of shareholder, because in the accounting knowledge or in the commerce knowledge there is two types of shareholders. One is preference shareholders and the other one is equity shareholders. So both of them are eligible for receipt of such dividend. However, no debenture holders shall enjoy the amount of dividend. Next, the amount of dividend is to be distributed by company based on the proportion of shareholding. It means, let's assume a shareholder is holding 10% of the total equity share, so the same person shall eligible for opting 10% return from such company. Dividend include interim dividend. Now what is interim dividend? We will discuss further. I hope this particular topic is very clear to you. If any doubt, pause the video. Again, hear this area. If any doubt still exists, then comment below. Next, from this section, section 2, section 2, clause 35 is the starting point of this particular chapter, declaration and payment of dividend. Now, as per section 235, dividend includes interim dividend. The the definition point is only lying the definition point is only lying up to this. This is what the concerned section 2 subsection 2 clause 35 want to mean. As per section 235, dividend means dividend include interim dividend. Now, as we discussed earlier, what are the type of dividend? There are two type of dividend. One is final and the second one is interim. I hope this is also clear to you. Next. Now, what is final dividend? And there are several facts regarding the final dividend. The amount of final dividend is recommended by BOD. BOD in the sense Board of Directors. The board of directors are the employee of the company and they primarily manages the fundamentals of the company, and therefore as per their view they recommend to the shareholders in a particular year that how much the company is eligible to pay, how much the company can afford the rate of dividend, and whether a company shall pay the dividend in a particular financial year or not. However, in a shorter note, the board of director of the company are instructed with the responsibility for recommending the status of the dividend. After getting recommendation from the board of directors, the shareholders will be eligible for making declaration or making announcement for payment of such dividends. The rate of dividend is is lesser than or is equal to the rate as recommended by the BOD. The rate of dividend, what I am said, is very crucial. The rate of dividend shall not exceed the rate as the BOD recommends. Please note one thing, this is the legal language you have to write or you have to use in your final, in your institute's examination. These are not storylines, these are proper legal words. Based on that words or based on these key words, you will going to achieve good score. So please focus the keywords as the ICI official material is determined, or if that are looks very complicated, then this can be act as a substitute. Correct? The only the portion of the keywords are will be act as a substitute. Only the portion of keywords. Next, the rate shall be determined on the nominal value or face value. On the time of doing accounting or doing advanced accounting, any chapters you may prefer, there is a component will appear called balance called authorized share capital in the balance sheet, and the authorized share capital is encrypted with a particular value. Say it rupees 10, say it rupees 100. The same value is to be called as nominal value or the face value. Or in other words, the value of equity shareholders is mentioned in the balance sheet of a particular company is the value called nominal value or face value. So the rate of the dividend, for example, the rate shall be 10%, then the 10% will be calculated based on the nominal value or the face value of the amount of the dividend. Next, what is the core difference between final and interim dividend? Please note before proceeding, I want to make a thing very clear that the definitions or the components posted in the right hand side of your particular screen is interim dividend, and the components exist on the left hand side of your particular screen is called as final dividend. So in the case of final dividend, the board of directors recommend the the eligibility, whether the company is eligible for paying of the dividend amount for a particular financial year or not, and if yes, then how much the particular company is open to distribute. After such recommendation, the shareholders will become eligible for making announcement that the company will pay or will held an organization, the company will conduct a operation for paying out the dividends. Similarly, in the case of interim dividend, the amount declared, the amount announced, and the amount recommended by BOD. In the case of interim dividend, the each and everything will be done by the BOD. There will be no involvement required for interim dividend of shareholders. In the case of interim dividend, the the amount shall be distributed out of the profit, and the gap of one interim dividend shall be sorry and the interim dividend shall be paid any time between two AGMs. There is no rule related to the final dividend. The rate of the final dividend cannot be increased once the recommendation from the BOD has came. However, the amount of the dividend in the case of final dividend once declared cannot be revoked by the shareholder or cannot be opposed by the shareholders. Once the final dividend is got declared, then it will be the legal obligation for the shareholders to pay among the shareholders. However, in the case of interim dividend, the dividend shall be declared at a maximum rate which shall be average of last 3 years dividend payout. We will discuss in detail further. The interim dividend or the amount of interim dividend after making declaration by the BOD, shareholder shall have the power to revoke. However, for such revocation, there shall be two conditions. The declaration for revocation or the announcement for revocation shall be done by the shareholders, or the consent of the shareholder shall be obtained by the BOD before declaring such kind of revocation orders. Next. Next section is section 123, declaration of dividend. First of all, under section 123, we will first discuss about the final dividend. So, what shall be the sources for distributing final dividend? Please be very careful from this section. The final dividend can be paid out of PL balance which the company earned in the current financial year. However, as we know, while calculating the profit and loss amount, several operating, non-operating, non-cash items we should include or we need to include. However, after obtaining the profit after tax, we need to we need to subtract several non-operating or non-cash items like unrealized gains. Such gains are still not realized. Notional gains, we are thinking as a company that we can achieve this portion or this amount of gain, but still we did not achieve that point. Or any kind of revaluation reserve which primarily appear on the on appreciation of the value of the fixed assets. Then we need to subtract any changes in the carrying amount of assets or liabilities which will be affected with the impact of depreciation. So for paying of final dividend, first source shall be the profit and loss account which we as a company earned from the previous year, sorry, from the current financial year. However, the profit of the current financial year shall come for this purpose only after subtracting unrealized gain, notional gain, or revaluation reserve and any changes in the carrying amount of assets or liabilities. Similarly, the second source shall be undistributable profit of any other preceding previous year. Any for obtaining the any unrealized profit of preceding previous year, we also need to reduce the amount of unrealized gain, notional gain, revaluation reserve, and the changes in carrying amount of the asset and liabilities. Or if we have insignificant balance or insufficient balance in profit of current financial year or profit of any preceding previous year, then we can utilize the amount in part from all of them too. It means we can partly utilize the profit of current financial year and partly we can use the profit of preceding previous year. That's why the third option you may see the both of the above is mentioned. However, the last sources shall be the such fund which the central government or the state government may provide to the company only for the purpose of dividend payouts. Next, section 123, declaration of dividend. We are still here in the context of final dividend. The losses of the P&L shall be settled with the current year profit prior to distribution of the dividend. It means the amount we determined based on the previous slides method, the determined amount shall be first set off towards any losses of previous year, if any. Then the remaining amount, whatever the amount may be, after reduction of the losses, after reduction or after setting off with the losses, shall be available for distribution as dividend. Next, section 123, declaration of dividend. Now, we are still in the section 123. However, we are now moving from final dividend towards the interim dividend. Next, in the case of interim dividend, the dividend declared by the board of director and approved by the board of director as well. Now, as we checked out or as we check out that There are several sources for distributing the final dividend. Likewise, in the case of interim dividend, we have several all sources also by which we can pay our interim dividend. So the first source shall be surplus of profit and loss of any preceding year or the current year. Second is current year profit. And third is current quarter's profit. Interim dividend actually paid between the two AGMs means the interim dividend shall be paid in current year, between the current year, and the final dividend is to be paid at the end of the current year or after finalization of the balance sheet of the current year. Therefore, as an interim dividend, as it is as it can be paid between the financial year, then we should also consider the amount of quarter, whether in a quarter we have profit or not in our company, whether or not we have profit or loss. So the the profit of such quarter we should also consider, for which the dividend is to be paid. Next, section 123, declaration of dividend. There are several provisions related to interim dividend. Let's discuss one of above. In the case of losses in current financial year up to the date of current quarter, it means if you have loss in the current financial year, which is which is especially the loss of your current quarter, then how can you determine, or how can you determine the sources of your dividend payout, or how much rate you shall apply for dividend payout, as you have losses and still want to pay the dividend for remain keeping the trust of your investors. So in this section, the Rule 3 of Companies Declaration of Dividend Rule 2014 is released, and as per such rule, the rate shall not exceed the average dividend of preceding three financial year. The first rule is the rate shall not exceed the average dividend of preceding three financial year. For example, we have declared a average rate of dividend in last preceding 3 year is 12%. So my current year rate of dividend shall not exceed the amount of 12%. I hope this is clear. Next, the total amount of the dividend payout shall be less than one tenth of paid up share capital plus free reserves. Now, free reserve, what are the free reserves? Free reserves means such reserves from which we can freely withdraw the cash, or we can freely utilize the amount of cash, which are not restricted by any law, or such reserves should not be opened for the purpose of any kind of statutory obligations. So the total amount shall be less than one tenth % of paid up share capital plus free reserves. One tenth means 10% of the paid up share capital and free reserves. The amount shall be the amount we determined. The 10% of paid up share capital plus free reserve shall be first be utilized toward the losses which we incurred in the current financial year. After that, if any amount is remaining, then such amount shall be distributed among the investors. The third point is the balance in reserve after withdrawal or after paying out such amount of dividend shall not be less than 15% of the paid up share capital. It means after paying out the dividend, we need to evaluate our free reserves, or sorry, we need to evaluate our reserve and surplus, and need to check one thing, whether the amount of reserve and surplus is at least higher than 15% of the paid up share capital or not. It must be it must be higher than 15% of the paid up share capital. So in this context, there are three prime rules. First is, we need to check at first the rate of dividend, we need to check the rate of dividend shall not exceed 3%, sorry, shall not exceed the average rate of dividend of the last three financial year. The total number of amount shall be less than one tenth of paid up share capital and free reserve, and after determination of such amount, the same shall be first set off towards the losses incurred in the current financial year. After that, if any amount remaining on the set, then the same shall be available for distribution among the shareholders. The third, after paying out of the dividend, the balance in the reserve and surplus shall be of higher than 15% of paid up share capital. It means the amount of reserve exists in the balance sheet is rupees 1 lakh after paying off the dividend, and the 15% of the paid up share capital is calculated as 50,000. Then 1 lakh is higher than the 50,000, then it is in accordance with the particular rule. However, if the amount of 15% paid up share capital is, let's assume it can be 2 lakh rupee, and as we have 1 lakh rupee in our reserve, then it violates the rule 3 of the company's declaration of dividend rule 2014. Correct? I hope this point is clear. Next, there is another crucial point. We need to notice that if any profit or if any dividend we didn't distribute in our last three financial year, then the rule available in the first row, which is the rate shall not exceed average rate of dividend of preceding 3 financial year, is the same will be omitted, is not applicable. I hope this is very clear to you. Moving ahead, as per section 123, there are particular timeline. Let's understand the timeline one by one. First is from the date of dividend declaration date. Within 5 days, the amount shall be deposited in a separate bank account. Which amount? The amount which is held to be distributed among the shareholder as dividend. Such amount need to withdraw from the reserve or from the prescribed sources in the case of interim dividend, and the same shall be placed on a separate bank account within a period of 5 days starting from the date of declaration. Next, from the fifth day, within 30 days, the amount shall be paid by the company in full or final settlement. Now, in this case, either company pay the whole amount to the shareholder in by using the electronic mode, or the company may issue share dividend warrants if the amount cannot be deposited by electronic format. However, if any amount is unable to deposit to the particular investor on account of particular investor, either by way of electronic mode or by way of dividend warrants, then the same shall be deposited to the unpaid dividend account within a period of 7 days. From which date? Starting from or the expiry of the 30th day, or starting from the 31st day. From 31st day to 31st day to next 7 day, the amount shall be deposited in the unpaid dividend account. And finally, within a period of 90 days starting from such 7 days, the company need to prepare a detailed statement for unpaid dividend account. I hope this timeline is clear. If not, then again recheck in this area, or if you have any kinds of doubt, then feel free to ask in the comment section. Next, after expiry of the 7 years, if no claim is received by the company, then the company is eligible, or the company is open for transferring such amount to the IEPF account. Now, what IEPF stands for? IEPF means Investor Education and Protection Fund account. This is a particular account which the CG for which the CG is empowered to open and maintain the account. We will discuss later on. However, for now we just need to understand the 7 day the seven the after the within the period of 7 day, the amount deposited by the company in the unpaid dividend account shall be kept for a period of 7 consecutive years, shall be shall remain on such unpaid dividend account for 7 consecutive years after expiry of 7 years. And if any investor didn't claim his amount from such unpaid dividend account, then the company need to or company shall transfer such amount to the IEPF account. Now, what is the process of depositing the amount to the IEPF? The company, first of all, mail to the IEPF authority, send a formal email for such amount, and detailed calculation of the shareholder status shall be mailed to the IEPF authority. After reviewing the mail by the IEPF authority, the company shall deposit the amount to the IEPF account. And after due diligence or after revision of the amount or the mail by the IEPF authority will issue an invoice against such deposited amount, and the same shall be preserved by the company as a document. Next, let's think a fact that if any amount is to be distributed by a company as dividend to its shareholder, then who will be or the group of person who will be eligible for receipt of such amount? First of all, the registered shareholder in whose name the shares are registered, the same registered shareholder shall be eligible for receipt of such amount. If the registered shareholder provided any kinds of direction for paying out of the dividend to the company, then the company can pay such amount of the dividend to any relative or any order of the registered shareholder, or the company can pay the amount to the banker of the particular shareholder. So now once again, who will receive the amount? First is the registered shareholder, next is to his order, and third is to his banker. Next, payout of dividend is not allowed in any terms other than cash and but bonus issue. It means the company, if a particular company promising to pay a dividend, then the company is not provide any kinds of product or any kinds of service in exchange of cash or other than cash as its dividend payout. Dividend payout means distribution of profit, and and as a result, the distribution of profit shall be in cash. There is no kinds of good or service will be allowed. However, in terms of or in exchange of issuing cash to the shareholders, the company can capitalize its reserve and surplus, which are freely available for distribution as dividend, by issuing bonus shares. Otherwise, there is no option for company to pay the dividend out. However, as per section 73 and 74, it has been found that a particular company is convicted and is in default. Then no payment by such company will be eligible until and unless such default continues by the company. However, Section 8 company who are primarily form or whose core objective rather is to conduct charitable activities are strictly prohibited for paying out the amount of dividend. I hope till now everything is clear to you, and if any doubts arise regarding section 123, feel free to ask in the comment section, or before commenting or before provide any kinds of comments, I would suggest to review this particular area once again. Okay, in section 124 we will be discussing the detailed provision related to creation and maintenance of unpaid dividend account. In the section 123, if you remember the thing that the company need to set aside the unpaid portion of the dividend to a particular unpaid dividend account within a period of 7 days. The 7 days shall be started from the 31st day. 31st day means the day the dividend was scheduled to be paid among the shareholders. So after such day, within a period of 7 days, the company is required to set aside the unpaid portion of its total dividend payout to unpaid dividend account, and within a period of 90 days, the company is required to prepare a detailed statement of unpaid dividend account. So in this particular section, section 124, section 124, we will be discussing the detailed fundamental and the law encrypted with the unpaid dividend account. So let's start. Dividend shall be paid within 30 days from the date of declaration, as we read earlier in the section 123. After the 7 day from the expiry of first 30 day, the amount shall be transferred to the unpaid dividend account. This much also we have learnt. Such amount shall be maintained in a scheduled bank. Such account shall be maintained in a scheduled bank. Now, what is scheduled bank? In this regard, the very crisp answer shall be the name of bank as per your knowledge is all are considered as the scheduled bank. Next, the company need to prepare a detailed statement after transferring the amount to the unpaid dividend account within a period of 90 days from the end of the 7 days, and the same shall be placed on the website of the company or any other approved websites. The detailed statement shall be placed two areas. First is the website of the company. It means, for example, Mr. X is operating its X Limited, and X Limited had its own website xlimited.com. So the X Limited shall prepare a detailed statement related to the unpaid dividend account, and the same shall be posted on the xlimited.com, its official website of the company X Limited, and if it wish or if it desire, it can post it on several other website, which is like SEBI website, which is like the NSE website, which is like the BSE website. These all are the approved websites. Next, what pro forma or what content shall follow in such statement? The statement shall contain the name of the shareholder, the last known email address and residential address or the registered office address of the shareholder, the amount of unpaid dividend. These three things shall be the prime content of such statement. However, the law doesn't restrict or doesn't make it exhaustive, right? This is in exclusive list. The company, as per its own motion, any component other than this, if it think that the same shall be then the same shall be putted on the particular statement, then the same shall be inserted. Moving ahead, if any company contravene with the provision as it is mentioned on the section 124, then such company shall liable for paying an interest of 12% per annum. Remember one thing, the interest amount of 12% per annum is to be drawn or attributable on account of the member or the shareholder. What does it mean? For example, there is an individual, Mr. Y. Mr. Y is investing in a company X Limited. Now, due to several reasons, the X Limited could not deposit the money of on account of Mr. Y, and Mr. Y from his own could not reimburse or could not redeem his dividend warrants. Next, and as a result, X Limited transferred the whole portion of Mr. Y to unpaid dividend account, and the company making several contravention by which the company need to pay or need to set aside such amount which is equivalent to 12% per annum as interest. Now, after after verification or after second request or subsequent request raised by Mr. Y, the company is liable to withdraw the amount of Mr. Y from unpaid dividend account along with the interest it need to pay on if it need to pay for which it making default. Correct. So the amount of Mr. Y shall be withdrawn from the unpaid dividend account and the same shall be deposited on account of Mr. Y along with the interest. Right? That is the third point of the first is written. Last point of the first bullet is written. Claimant shall communicate with the company for such receipt. Yes. Next. After expiry of the 7 year, the amount shall be transferred to IEPF account. We already know this. Amount of the dividend plus share capital. The amount of the share capital shall be eligible for transfer to the IEPF if any member doesn't accept the return on share for 7 consecutive years. If any person holding, for example, if any person holding a share of rupees 1 lakh and it it was unable to receive any kinds of dividend for such share worth rupees 1 lakh till the last 7 consecutive years. Consecutive means continuous 7 years. It unable to receive such amount. So what will happen with such share? The amount of the dividend shall be deposited to the IEPF account alongside the amount of the share worth rupees 1 lakh shall also be deposited with the IEPF account and the same and the ownership of rupees 1 lakh share will be lost by such person. Next, if any contravention made by the company for performing any of the provision as per section 124, including the interest of 12% per annum, the company shall also be punishable at minimum 1 lakh rupees as its fine plus 500 rupees per day, and maximum it can reach up to 10 lakh rupees. However, in the case of officer in default, minimum fine shall be 25,000 one time and rupees 500 per day, and maximum shall reach up to rupees 2 lakh. Now we will be discussing the section 125, which is primarily talks about the provisions related to the IEPF account. So let's start. The first provision says that the CG means the central government has the power or the responsibility for establishing an account which shall be named as Investor Education and Protection Fund account. Next, who shall be the constituents of this authority? The chairperson. There must be a chairperson. There must be a chairperson. The chairperson shall be the ex officio of MCA secretary. MCA means Ministry of Corporate Affairs. There shall be a CEO. CEO shall be appointed by the government. There shall be members of not more than 7%, including the chairperson. In this area, CP means the chairperson. It means, or in other words, if we can say that if we reduce the number of chairperson, then we should only take 6% as the member, and including chairperson, there shall be 7 members. Next, the IEPF authority must prepare its account and the same shall be audited as the C&AG may prescribe. C&AG means Comptroller and Auditor General. Then submission of such audit report is attributable to the office of the central government. Next, the next provision is preparation of annual report by IEPF authority. The annual report shall be prepared and maintained in the format as the Companies Act 2013 is provided for other companies. The same shall be preserved in this area also. After preparation of such annual report, the same shall be submitted to the office of the central government, and in on the session of Lok Sabha and Rajya Sabha, the central government placed such report before the houses. The next provision is related to the inflows and outflows of the IEPF account. As this is an account, yeah, therefore it have the credibility of crediting several amount and debiting several amounts. So we just understand from which sources it can credit its balance and from which sources and to which sources it need to debit its account. First of all, the inflows by way of grant or donation by the CGSG company or any other institution. There, if central government, state government, any company or any other institution want to provide several donation, then the amount of the donation is or the amount of the grant is credited to the IEPF account. Next, remittance from unpaid dividend account, matured debentures, deposits, or maturity of preference share capital for which 7 years has been elapsed. It means in the case of unpaid dividend account, matured debenture, matured deposit, or preference share, matured preference shares, these all are matured. It means the tenure of their redemption has arrived or has completed. Now there can be several complication on the side of the investor or on the side of the on the side of the investor, and therefore it cannot be redeemed by such individual or such investor, and therefore the same shall be transferred previously to the unpaid dividend account, and after transferring to the unpaid dividend account 7 years has been elapsed, and therefore it shall be credited to the IEPF account as we read in the section 124. As there can be several credit in such account as per IEPF Act 1956. However, sale of fractional shares. If any investor sold or if any company sold its fractional shares and the amount is not claimed by any investor and the 7 year also have been elapsed, then such amount is also to be debited, also to be credited to such account. Next, shares held by IEPF authority. Shares held by IEPF authority as per section 90 subsection 9. The income from such shares is also to be credited to the IEPF account. Next, disgorged fund. Balance in the disgorged fund also to be credited to the IEPF account. I hope the inflow area is pretty clear. Next, we are moving towards the outflows. Section 125 IEPF account, we just reading from to which sources it need to pay or it need to disburse its fund from the IEPF account. First is proceedings with respect to refund. Refund to whom? Refund to investors. This is one example, but refund to be other as the situation may permit can be done. In the case of investor, let's assume the amount of such investor is deposited to the unpaid dividend account, and after expiry of the 7 years the same has been transferred to the IEPF account. Now when the amount is transferred to the IEPF account, the claimant or the investor raise request directly to the IEPF authority for such refund, and in this area such authority is pretty liable for paying out or for creating or for conducting the refund proceedings for such investor. So therefore the main outflow shall be the refund initiatives. Next, utilization towards the core objective of the fund. As its name expresses, IEPF means investor education and protection. It means to educate and protect the investor. This is the core objective of such authority. So for maintaining its liability towards the investor, education and protection of such investor is is the core objective, and for this objective it need to utilize its funds from such account. Distribution of disgorged amount or refund of disgorged amount. The amount it has been previously disgorged, and after settlement it need to settle the same amount as disgorged amount. Next, reimbursement for class action suit. In the case of any legal expenditure or payment of legal expenditure in the favor of central government, the, the legal expenditure or the amount of legal expenditure is to be refunded or is to be debited from such account. Correct. Next is any other manner as the IEPF Act 1956 may prescribe. Now it's time to read section 126, which is right to dividend, right share, bonus share to be held in abeyance pending registration of transfer of the shares. In this particular topic, There is several or certain areas you need to understand with utmost care, and this is why you are particularly required to hear on my words rather than what is presented in front of you. So let's start this. In the visuals you will find that a timeline is prepared. This is an example, not any kind of fixed or statutory timelines. This example will help us while understanding this particular provision. Now, as we can see from the visual that as on 1/4/2021, Mr. S is an individual, is a holder of several shares. However, on 30/4/2021, Mr. S determined that he shall sell all of his holding, and therefore he started the process of selling of his own shares on 30th April 2021. However, the ultimate effect or the ultimate registration of such sale was taken place on 30th 7 2021. Means on the process of sale started on 30th 4 2021. However, the process of sale got terminated on 30th 7 2021, and the new holder became Mr. J. Mr. J became the new holder on 30/7 2021. Now in the whole proceeding or during the whole proceeding, on 1/5 2021, the company declared the dividend for such shares. Now, the important question is who will receive such dividend? Because the before the due date of dividend or before the date of payoff the dividend, Mr. S started the proceeding for selling. However, as on the date of dividend, there is no new shareholder, although the existing shareholder terminates his right. How? The existing shareholder, Mr. S, when started the proceeding on 30th 4 2021, he immediately lost his holding. However, Mr. J, the new shareholder, was became the holder on 30th 7 2021. It means the period starting from 34 2021 to 37 2021, there is no holder for such share, or there is no permanent holder for such share. In this case, if the company want to pay out several dividend or bonus issue, then Mr. S, the previous owner of such share, need to provide a written declaration with his consent that he started the proceeding of selling such share and Mr. J shall be the new holder, and every dividend or bonus share shall be provided to Mr. J in the case of only dividend payout or bonus issues. In this way, once the company got recognition or got instruction from the previous owner of the share, then the company will start proceeding for providing such dividend or such bonus issues to Mr. J, the new holder, once Mr. J officially became the holder. However, in the case of 1/5/2021, let's assume there is no due date for dividend, rather there is a due date for right issue. Or yes, there is a dividend, there is a opportunity or due date for right issue. Now we all know right issue is such issue where existing shareholder will be provided with such right for buying their shares in very low price as compared to the market price. Now, in this case, there is no instruction will be worked. There is no instruction or direction will be worked of Mr. S, as he is the previous owner and he cannot determine the any decision for new issues. Correct. So in this situation, in the case of right issue, if the if the existing shareholder got terminated and the proceeding of selling is still going on, then the company will reserve all the share, including the right issues in abeyance. Once the new shareholder became the official shareholder or the registered holder of the company, then the company will release his areas or release his pending or dues. I hope this is clear. If not, then comment down. We will answer obvious. However, moving ahead towards our next section, which is section 127, punishment for failure to distribute the dividends. It means if any company defaulted after declaring its dividend, but defaulted where? Defaulted in anywhere on the time of declaration, on the time of dividend payout, anywhere if the company got defaulted, then there is two provision. One is imprisonment and the second one is penalty. Now in this section, company as a company is not a natural entity. Therefore, there is no concept of imprisonment in the case of company. However, such company shall pay 18% per annum as interest, which shall be simple interest. Now, in the case of officer in default, there shall be a imprisonment not less than 2 years, or penalty of not less than 1000 per day till such day up to which the default continues. These are the legal words. Please make a very clear notes regarding this. Correct? So, this is the basic punishment written on section 127. However, there is several exception to this section. What are the exception? If the following condition are satisfied by the company, then the law will assume there is no offense created at the end of the company, and hence the company shall not be liable for penalty or imprisonment. Correct? So, what are the facts or what are the reasons? The first is operation of the law. Operation of the law means the company was unable to pay the dividend to its particular to any of its investor due to the restriction imposed by law, restriction imposed by respective law. So this is not a default from the end of the company. So there is no default. Dispute in right or ownership. The company is cannot or is unable to determine to whom the amount of the dividend shall be paid. On the other hand, the investor and his other family member is creating several litigation regarding their legal hair issues. And in this reason, or as a result, as the company is not responsible for determination of legal hairs of a particular investor, therefore it cannot or it can reserve the payout of the dividend till that time when they resolve the whole matter. Next, lawfully adjusted. Let's assume in a case of share issue, the company owes from the company to be received. Let's assume rupees 5 out of its rupees 10 share issue from its investor. It means a particular investor has a liability to pay balance rupees 5 for its shareholding to the company. Now, in this section, as the company has a receivable balance from such investment, therefore the company has the exclusive right to set off the dividend attributable to such investor with such unpaid amount. Right? This is called lawfully adjusted. Next, the direction of the shareholder can't be complied with. Let's assume a particular shareholder directed the company to pay the dividend to his particular person or relative. Now, on the time of payment, the company came to know that the such amount shall not be paid to such relative or such instruction or as according to the instruction of the shareholder, and hence the company did not pay the amount to such person. So this is not a default from the end of the company. Next, or any other reason for which company is not defaulted, for which the ultimate liability or the ultimate burden will be shifted towards the shareholders. Correct? So, due to these reasons, or if the company is unable to pay the dividend by performing this kind of conditions, the default shall not be assumed on account of company, and hence the company shall not be liable for any kinds of penalty or imprisonment, neither company nor its officer in default. Next, in the case of Nidhi company, in case of Nidhi company, if the overall dividend payout is less than 100 rupees, then the company shall not make it then the company shall not go into the, or shall not undertake several long term processes or complicated processes. Rather, the company can make an announcement in the newspaper or put a notice regarding this payout on its notice board of the company for 3 months. If these two can be performed by the company, then it shall be deemed that the company will sufficiently complied with all complicated or complex provisions of this section or of this chapter. Correct? With this, we conclude the whole chapter called Declaration and Payment of Dividend. I hope this video was helpful for you, and in your screen you will find the email address provided by us. This email address is provided for the purpose of sending any kinds of query related to this chapter to us, and we will try our best to provide you the required solutions. Otherwise, you may comment down below of the video from where you also receive the answer of your doubt or the resolution of your doubt. And in this point, or in this particular note, I want to request you that please visit the description section of the particular video, and you will find the link for Google form, where you should fill up the Google form, and you must tell us the video or the next chapter we should pick up for revision. Correct? So that's all. I am your instructor Shantanjana, signing off for the day. Have a great time ahead. Thank you, guys.